People always say that you have to have money to make money, and that there's an extraordinary level of sacrifice on the road to success. So how is it that investors like us, who didn't start out with much money and who don't rely on banks and credit, how is it that we can increase our income and build our wealth in a way that doesn't require us replacing one full-time job with another while still enjoying the things in life that matter most to us? That has always been the big question, and this podcast reveals the answers. I am Carrie Like, and this is the Investor Warrior. Hey guys, and welcome back to the Investor Warrior Show. Today I'm going to bring on Andrea Hosch, who's actually a very good friend of ours. She's a business partner, a friend, a mom of 4 amazing kids who have babysat my kids. I look up to her in a lot of different ways, and we've worked together over the years on a lot of different stuff. And she happens to be a partner at Commonwealth Trust Services, which is the land trust company that we use for all of our land trust needs. And you guys have probably heard me talk about land trusts on this show, and that's because I think I have bought 2 properties in the 10 years of doing this without a land trust. And I happened to be living in Georgia when I bought those properties, and I didn't know much about land trusts. And we can go into the story around that when I didn't use a land trust, because it caused a lot of problems that we're going to talk about on today's show, and why we use land trusts. And it doesn't matter if you are in Florida or you're in another state. We're going to talk about that because Commonwealth actually works with different states. And I know different states are more familiar with land trusts, and they're more friendly with land trusts, and some aren't. And so we can talk about that with Andrea too. But I'm going to go ahead and bring Andrea on the show, and we're going to get into why using land trusts with purchasing real estate is just an amazing tool. Hey, Andrea.
Hi, Carrie. How are you?
Good. Welcome to the show.
Thank you. Happy to be here.
So like I said, you guys, Andrea and I have worked together. I don't know how many projects we've done together, but I do remember the first time we really met and started talking about real estate. We were in the courthouse. I don't know if you remember this, but
I do.
I was in the courthouse, and I was researching probate, and I happened to run into you at the courthouse, and you were doing your own research. And I was really struggling at the time because I was putting marketing out, but I couldn't be there when the phone rang because I think Cameron was little and Danny was a baby. And it seemed like every time the phone rang from my marketing, I was not available to answer the call. And so I was telling you that was my struggle. And you were like, really? Because I'm putting a bunch of marketing out and I have time to answer the phone, but my phone's not ringing. And I was like, oh, we should partner together. Like, this would be awesome. And so formed our partnership.
Yeah.
So,
yes.
So you and I have worked together over the years, and now we obviously use you for land trusts. So let's just go into what land trusts are and start from there.
Okay. Well, a land trust is a little bit about me too. I am an attorney. I'm a realtor. I'm an investor. So over the years, actually, I've been an attorney, obviously, for a long, long time. And I didn't know about land trusts. So land trusts are kind of they're not supposed to be hidden because they're in Florida. They're on the Florida statutes, which is awesome. But most people do not know about them. Only really start to become familiar with them when you enter the investor world. And that's because a lot of investors use them to title their property interest in, so it's not in their own name. That's kind of the whole reason you would want to use it, or the biggest reason.
Right.
So a land trust is a statutory trust. It's a revocable trust, like other revocable trusts. The difference with a land trust is you can only put a property interest into a land trust. A revocable trust just basically means that the settler, the person who's forming the trust, putting it into trust, also has the power to revoke the trust. So a land trust is a very cool tool because in a land trust, the trustee has the only thing the trustee can do is at the direction of the beneficiary through a land trust agreement. Now, on public record, the trustee has all the power. So just real quickly how it works, it's pretty simple, but it requires two documents, which one is the deed to trustee. So it's the recorded instrument. Now, mortgage can also go in a trust. So whatever it is, though, it's going to name, the deed is going to name the trustee as the grantee. So now this deed or this mortgage is being held in trust for the benefit of, but they have all the power to sell, convey, transfer, do all the things with this property. So the first thing that pops up when people hear about that, they're like, wait a second, I don't want somebody else having all the power over my property. It's like, well, take a step back. The second document is the land trust agreement, and that is a contract between the trustee and the beneficiary that gives all the power back to the beneficiary to direct that trust. So they have the power of direction. So even though the trustee has all the power on public record, which they need because that protects the privacy of the beneficiary, they can't do anything legally because they're bound by contract without being directed by that beneficiary. So it works super well for investors. We also have here at Commonwealth, we have over 400 trusts going on at any given time, and probably only about 5% of those are non-investors. Sometimes we do get some people, for whatever reasons, they don't want their property on public record in their name. And when I say on public record, a lot of people that really aren't familiar with how that all works don't realize that anyone can go in, I think every state in Florida can go to the county website and find out who owns a piece of property or who the title owner is. So even in Florida, even if your title owner is an LLC, you can then take a step further, go to the Division of Corporations in Florida and pull up who's involved in that LLC. So the only way really to protect your privacy in Florida and most other states is to title it in the name of a trust that does not require the signature of the beneficiary. And that's what makes a land trust a little different than other revocable trusts. Most other revocable trusts that are formed for estate planning purposes are usually going to either have the beneficiary as the trustee because they're putting a lot of assets in there and they want to be the trustee and in control, or it's going to require their signature in their trust documents. It's going to require their signature, the beneficiary, to sign off on any movement of those assets. Whereas a land trust, as you and I know, we've bought many properties in trust and sold them out of trust, and nobody ever knew that we were the owner. So the only one that knows that we're the owner are our accountants and, of course, our trustee. And the accountant, of course, your IRS records, your IRS, tax forms and things are not public record. So that's the other thing that's cool about a land trust is the trustee has no responsibility with regard to taxation or management of the property. All of that filters through to the beneficiary. So a land trust is transparent as far as the IRS is concerned. It's a non-entity. It does not have a tax ID number. The tax ID number that's associated with any profits or losses of that property is going to be the beneficiary tax number. Now, if you're holding the beneficial interest in that trust in your own name, then that's going to be your Social Security number. If it's your LLC, your corporation, or anything like that, it's going to be the tax ID number or the EIN number assigned to that corporation. Now, the other cool thing about a land trust is that you can have many different beneficiaries. I mean, you could have your IRA, even your HSA, any kind of retirement account, anything that has tax ID or tax consequence can be the beneficiary trust. I'm getting to other points.
Yeah. Okay. Or as soon as I get on here, I love my little gets in the way of things. Okay, it's off now.
Okay, see if I can hear you.
Can you hear me now?
Yeah, I just turned you up just a little bit.
Okay.
So retirement account, all those kinds of things. And the other cool thing is you can really form secure partnerships in that. So the biggest benefit, and the reason that most investors want to use it, is because it protects their privacy. And as we're growing as investors, our biggest, probably most of us, our biggest asset or our tool to sort of grow our assets is through real estate. So you may own, 5, 10, 20 properties or more at a time. To have all of that out on public record basically shows everyone what you own, as opposed to people that are growing their retirement or whatever in the stock account or their bank accounts. Those are not searchable. So it really becomes an important tool. But the second benefit is the lien and judgment protection. We recommend at Commonwealth that when you form a trust, you make it unique to that property. So each property goes in its unique trust. So if there's you say you have 4 or 5 rental properties, or even 2, and you have one rental property that's an issue, you've got some code lien violations, or you've got some city violations, something you're working on. Well, if that's in the name of your LLC, titled in the name of your LLC, and your other one is also titled in the name of your LLC, and you're trying to sell that one, it's going to be an issue. They're not going to let you sell one out of one property in the same state when you have liens, the same county, especially when you have some outstanding liens or business that needs to be taken care of on the other property. And also, it protects you against yourself. I mean, we're out there living life. We have kids that are in college and driving. We're driving. All the kinds of issues that you can have, and the lawsuits and judgments that can go against you personally, are not going to affect that that property that's held in trust, because it's titled uniquely. So that can be really important, and it's important when you're going to partner with somebody. So, I almost always do deals with partners, and I don't have to worry about what's going on in their life. I don't have to worry that whatever else they're dealing with, they may end up with a judgment or be in the middle of a lawsuit when we go to sell this property, because our property together is titled uniquely. So that makes it really nice.
Yeah. And talk to you about successor beneficiaries and probate when your property is in a trust, because that's really important too.
Yes, that's another benefit. Probably the number 3rd most popular benefit is the successor beneficiary ability within the trust. And we have like that 5 to 10% of people that we hold, properties in trust for them, that they are not necessarily investors where they're trying to get more rental properties. Those people fall into that category where we probably get a call once or twice a month saying, hey, my parents are getting elderly. We'd like to go ahead and put their property in a trust now. We'll get named as a successor beneficiary in the land trust agreement. So, when something inevitably happens to them, it will flow to us without the need for probate, because it's in the trust already set up that way. So that, as we know, that's going to avoid some probate costs and headaches.
Yep. And then let's talk about keeping purchase price off of public record when using a trust, because that's really important too. Anytime we purchase a property, it's in our best interest to keep that purchase price off public record, especially if we're going to be flipping the property. And I think we touched on this on the last episode with Howie and I. When you purchase a property for, let's say, $100,000, and 4 months later you're selling it for $250,000, even though the value of the house is $250,000 and you've put money into it and you're selling it for what the value is, anyone can go on public record and see the purchase price history. You bought it for $100,000, 4 months later you're selling it for $250,000, and that can obviously sometimes raise questions and bias with the buyer. Just naturally happens. So how can we use land trust with that?
Yeah, and not just the buyer, but the appraiser, because the appraiser will also see that. And even though the appraisers understand a little bit more than the general public that, hey, there's a new roof, there's new wiring, there's new plumbing, that the appraiser is not necessarily going to give you more in the appraisal for new wiring and new plumbing and that sort of thing. And I think it sticks in their mind, and also it can become one of your comps if it's a quick flip.
Right.
And I know we've had a situation in the past too, where luckily it was in trust, because some lenders, especially FHA lenders, will push back for a second appraisal if it's purchased within 90 days, and then so that can be a problem. So putting it in trust can also help with seasoning. Sometimes you can get it into the trust even before you close on the property, so that can be helpful when you know you're going to do a quick flip. But watching the purchase price or protecting, keeping it private. I mean, I don't want to say really. It covers the purchase price because the doc stamps are actually triggered on the transfer of the property from one person or entity to a different person or entity. So it's the change of control that triggers the payment of doc stamps. And typically, in probably 95% of transactions, that's done through a deed. So when doc stamps, when there's a transfer of deed and the deed goes to the county expects that, they're going to get some doc stamps with that, and indicating, what is it, 0.007 is the doc stamp fee. So they're going to extrapolate that back, and they're going to post a purchase price based on the amount of doc stamps that they get in at the county. So that's when the deed is the transferring document. So what happens in a trust is when the seller places the property into trust, the deed is not the transferring document, because the trust actually in that circumstance is not purchasing the property from the seller. The seller is setting up the trust, placing the property, becoming the settler of the trust. So the deed's going to go into the county with no doc stamps, just a minimal, like 70 cents on $100, because that seller, anyone can place their property into trust. So you have the right to do that. The next document, and typically it's handled at closing. Sometimes it might be a little bit later, but the next document within the trust is going to be an assignment of that seller's beneficial interest in trust to the end buyer or the next purchaser. And that becomes the transferring document. That assignment, which is not recorded, it's an unrecorded assignment of beneficial interest, is what triggers is the change of control and triggers the doc stamps. Well, that assignment, since it's unrecorded, you're not going to send it into the county. It's actually not going to go anywhere. But the Department of Revenue, in an effort to capture all those doc stamps, they've actually made a special form, a DR 228, and it covers a lot of unrecorded transfer documents, so that then you send the doc stamps directly to the Department of Revenue. So the doc stamps are still being paid, because a lot of people will say to me, I've heard if you push your property, get the seller to put it into trust and transfer it to you, you don't have to pay doc stamps. Well, that's not true. You do have to pay the doc stamps, but they go to the Department of Revenue, where the county, they bypass the county level. So the Department of Revenue doesn't post the sale price or anything like that. I mean, that's not what they do. It's that all that information is collected at the county.
Yep.
So that works great. And we typically, I'm sure you've talked about on this show, you've talked about subject to transactions when you purchase a property subject to the mortgage. So perhaps you're purchasing it from a seller, you're going to leave that mortgage in place because for whatever reason, maybe the seller, basically their mortgage is what they can sell the property for. So you're going to keep that underlying financing. You're going to take over those payments, also called the TOPS program. Some people teach it like that. But you're going to leave that mortgage in place that has the prior seller's name on it. There's some other documents that we can also do within the trust that makes the sellers feel comfortable with that. But it's great in those types of situations if the seller can be the seller of the trust, place the property into trust, then assign their interest, because it doesn't then look like a sale on public record. It just looks like they placed it into trust, and it's not necessarily a red flag for the banking institutions, because most lenders are going to have a due on sale clause, and it doesn't nullify the due on sale clause, but typically they don't want to call in their loans that are performing. So a lot of times as investors, when we take over people's mortgages, we're actually helping them. I know you and I did a couple of transactions that way, and it actually improved the credit of the sellers that we dealt with. So that's another great way to utilize a land trust, and pretty much the only way you can do subject to transaction and keep the sale price off the public record.
Right. And then I think you touched on this a little bit, but when you're partnering with people, it's really important to use a land trust because the partners don't actually own the property. The land trust owns the property, and then the partners become the beneficiaries. And so, what does that do within the partnership? Like, how does that protect the partnership?
Well, there's different documents that you can utilize within the land trust. Like I know a lot of people partner in LLCs. They use, or their two LLCs might partner, and maybe they'll use a beneficiary agreement. The first thing that protects the partners in the trust is your percentage is going to be spelled out. So typically, you know, everyone, it's very apparent, and there's an upfront instruction to the trustee that, hey, when that property gets sold, this is the way the proceeds are going to be dispersed, is in this percentage. Now, obviously, there's, like I started to say with the joint venture, what we do with the land trust is there's a beneficiary agreement. So a lot of our clients will put just a simple agreement together, just kind of indicating what their rights and roles are with regard to whether it's a flip or whether it's a rental property. And then that is kept in the trust file, and the trustee accepts that. So in other words, we're agreeing, all we're doing is we're agreeing as trustee that anything that comes to us in direction, we're gonna use that as a guideline. So there are several different things you can put in place. I know sometimes when maybe one partner may put up the money, put up the funds, they might have a mortgage with either their company, or some of them lend through a lender trust against that property, and perhaps there'll be an agreement within the trust paperwork that that property will remain in trust during the term of the financing. And that's also something that is popular with lenders, especially hard money lenders. If they're going to loan, a lot of private and hard money lenders, they really like using lending to a trust, because they understand the fact that, hey, if it's in a trust, it's apart from what these people are doing outside of their business, how they're living their lives. We don't have to worry that this property is going to get mixed up in something like that. So they want to do that, and they'll say, hey, please add the language or add an addendum that says this property will remain in trust during the term of this loan. So it works really well. And the other thing that it does on the borrower side is, if you have multiple properties out there and you have a lot of private money loans, it's not going against your credit, because these are all mortgages against each individual trust property, not against you. Now, you might sign a personal guarantee, but that's not recorded. So that really helps. It doesn't make you look like, you go to open a Visa card, and all of a sudden it's like, no, because you have $2 million out in private loans. That's not going to show up.
Yeah. Yeah. As a lender, I would always require that the purchaser put the property into the trust, because that's going to protect my interest in the security, right? My money is being secured by the asset, and I want that asset protected as much as I can. And so if someone's going to purchase a property, I want it in a trust, because then things that happen in their personal life, things that happen to their other properties, aren't going to affect this property that I have a security interest in. And one thing I want to touch on, though, is there are certain circumstances where you're not going to be able to use a trust, such as conventional bank financing. I don't know about you, but have you ever run into a situation where a conventional bank will lend with a property in a trust?
Not a for residential, like residential purchases, we have not had a big bank like a Wells Fargo or a Bank of America. They are not going to lend to a land trust.
Right.
However, we have had smaller commercial banks. They really seem to get it, and we've had several successful loans on commercial property, multifamily, like apartment complexes, large pieces of land. They're going to be built on commercial. They have no problem so far using trusts, and they understand that the trustee in those types of circumstances, we only sign the mortgage because they're securing the asset, they're securing their funds with the asset, and we are the title owner. So as trustee, we're signing the mortgage. but the borrower beneficiary is signing everything else.
Right.
On the few times that we have had a little bit different than a hard money lender, more of a traditional lender, but still not what I would call a big bank, do a residential loan. It's only happened a few times, probably 10 times over the last couple of years. They've still required the trustee. They don't quite get that the only thing that we're responsible for is the asset, is holding
Right.
title to it. They still want us to sign everything. Of course, we only sign as trustee under the specific Florida statute, which limits all of our liability. But they have required us to do that.
Yeah. I would say too, we've run into certain title companies that don't understand it either. And
Yes.
it's
Yes.
so important to use a title company who understands land trust. I know, like, I don't know, we were selling a property and the buyer wanted to use their title company, and this happened just a few months ago, and you and I got on the phone and you were like, "Oh my gosh, if we have to use another title company, like, I hope this title company understands trust, because even just
Yeah.
selling the property can be an issue when it's in a trust and I'm selling it and we're using someone other than our title company."
Yes. Yeah. Selling a property becomes an issue just really on the tax side and the disbursement side, because they
Right.
don't understand that the land trust doesn't have a tax ID number. So they want to use Commonwealth's tax ID number. Well, that property doesn't belong to us. We never had anything to do with it. We don't get the proceeds. We don't. So that's a little bit of a struggle. And then of course, if they don't want to disperse directly to the beneficiary, that causes us some issues. I mean, we can overcome those issues, but it's
Right.
nicer if you use someone who understands trust.
Yeah.
However, the more important thing is to use a title company, not just an investor-friendly title company, but you need to ask them some pointed questions if you're going to use them on a transaction that you want them to send the doc stamps to the Department of Revenue. We have had title companies say, "I don't understand this. I don't think this is legal. I'm not going to do it." Like 2 days before, I send them the Department of Revenue form and the administrative rules, but they still won't do it.
Right.
So that becomes a problem, because you're either closing and you're going to see your purchase price, or at the very last minute, you're trying to get extension from your seller to move to another title company, and you're having to pay additional title costs. So I always tell people, more than just everyone will say they're investor friendly. And I mean, if someone's purchasing directly into trust, that's typically never a problem. Even if they won't use our deed, we'll send them our trust powers, and we'll make that happen. But it's always the little bit extra step that it takes to keep that purchase price private, that some title companies just will not do. So, and I always tell people, I said, when they call me, or right away when they put their trust order in, if it's a title company I'm not familiar with, we'll usually shoot them an email and say, "Hey, have you talked to them about the way you want this transaction?" And then if not, then I've talked to lots of title companies to try to educate them. And most, I would say the majority want to learn. You get that small percentage, like 20% maybe, that is like, "I'm not doing that. I've never heard of that." So, and the worst thing is when the seller has picked that title company and they're talking about the sellers, like, "My sellers aren't going to do that." You've already talked to your sellers and they said they would, but then when the title agent calls them up and says, "Oh, I don't think you should," we've seen a couple that title companies ruin a couple of deals.
Yeah, and that is the worst thing. You never want to cause confusion with the seller. So I would say always fight to use your power team, your attorneys, your title company, because they know how you operate. They know how you're going to structure this transaction, and then there's going to be no confusion for the seller. That is like the worst.
Yeah, and I see it mostly becoming a problem when there's a realtor, representing that seller. So you're not even able to speak directly to the seller. And so that when that happens, you really need to get it in your contract so that there's no issues at the end, because a lot of realtors will say, I'm a realtor, and a lot of realtors don't understand this, and they'll make some promises up front, like when you say, "Oh, but I really want the client to place it into trust." "Oh, yeah, that won't be a problem." Well, then by the time it comes to the end of the transaction, they don't understand it. They're not going to do it. It's not written in the contract. It's not.
Yeah.
So.
Another Another thing that I've also run into over the years is when I tell people or I ask them, do you work with land trust, or will you lend on this if we put it into a land trust? And they'll say, oh, yeah, we'll lend on it if it's in a trust, because they're thinking a living trust. And I
Right.
really clarify, okay, this is not a living trust I'm talking about. It is
Yeah.
a Florida land trust. And I've actually had
Yes.
lenders say, oh, wait, well, let me see, because I thought we were talking about a living trust. And sure enough, they went back and they said, no, we don't. We can't lend on a land trust. So
Yeah.
I think as soon as people hear trust, whether it's a title company or a lender or someone you're working with, they say, oh, yeah, we'll do a trust. But then
Right.
when it gets down to a land trust, which is very different from a living trust, then questions arise and then they might not be able to, which is not good when you're coming down to the last couple of days before closing and you find out that we can't
Right.
do this in a land trust.
Yes.
Yeah.
We've had that happen lots of times. So more recently, I'd say in the past 6 months, we get whenever they say, "Oh, we're going to use this lender," they say they'll lend to a trust. We go back and forth with them immediately, send the trust documents immediately to that lender, and we've had much better success that way.
Yeah.
So, because just getting all the information and having them submit it to their underwriters early on in the process is what it takes. And the last couple we have been able to do to the trust, they were fine with it.
Mm-hmm.
So of course the borrower is going to have a personal guarantee and all of that type of thing. So
Yeah. So, guys, just as a recap, I'm going to give an example of a house that we're going to purchase and we're going to put it into a land trust. So, let's say I negotiate a purchase price of $100,000. I'm going to be buying this directly from the seller. We're going to be using a private lender to fund it. And let's say I'm going to be bringing a partner in who's going to put up some of the funds, and we're going to partner on this deal. So I put it under contract for $100,000. One of the things that I need to do in my contract is either have the buyer as my land trust company. So that's going to be the purchaser on the contract, or I can put my company as the buyer on the contract. It has to be an assignable contract. And then somewhere on that contract is going to say, for the purpose of closing this transaction, the property may be placed in a land trust. So that way, at closing, I have the option to assign it to the trust, or if the contract is already with the trust as the buyer, then we're good to go. What's going to be dependent on what is different about those two different ways of doing it when you put it under contract is if you put the buyer as the trust company, then the trustee has to sign that purchase and sale agreement technically, because let's say Commonwealth Trust Services is going to be the buyer. So I'm going to have my trustee at Commonwealth Trust Services sign that purchase and sale agreement. If I put my company and it's assignable and I put the language in there to be able to transfer it into the trust at closing, then I can sign it. So we've got the contract signed. We're ready to close the property. I've already explained to the seller, and this is also important, is explaining to the seller land trust and how the paperwork is going to go. But just as a recap with the paperwork, the best way to do this, I think, is for the seller initially to deed it into a trust. So the first paperwork you're going to have is a warranty deed to trustee. That's the seller deeding the property into the trust. And on public record, it goes from the seller to the trust. And now the seller is the beneficiary of that trust. They have a land trust agreement with that trust. They are the beneficiary of that trust. But immediately after they sign the warranty deed and the land trust agreement, they're going to sign what's called an assignment of beneficial interest. And that basically assigns the beneficial interest from them to, let's say, your company. Usually we use our LLC or our corporation as a beneficiary. And now we are the beneficiaries of that trust. And now we have a land trust agreement with our trustee. And that none of that takes place on public record. The only thing that takes place on public record is the deed from the seller to the trust. And then when they transfer their beneficial interest to us, that stays off public record. Now our company stays off public record. Our name stays off public record. And now the trust owns the property, but we direct the trust on what we want them to do. So if we want to sell the property, we tell the trustee to sell the property. If we want to, I don't know, if we want to, I'm trying to think of what other powers there would be when I email you guys.
Another cool thing we didn't even touch on was like, say you have a rental property and you decide, hey, I'm gonna, sell this for whatever, and
Hmm.
my fellow investor would like this rental property. You
Yeah.
can sell it to them on an assignment. The
Hmm.
title insurance policy is in the name of the trust, so that doesn't change. They can keep the same title insurance policy. You don't have
Right.
to use a title company, so it helps with some costs. You just need a simple settlement statement for both sides for your accountant, and an
Yep.
assignment of beneficial interest, maybe a new management agreement. So that's a really cool thing too. That's done a
Yep.
lot between investors.
Yep. That's a good point. So at closing, you guys, the trustee signs all the paperwork. I don't remember the last time I went to a closing because what I do is I just review all of the documents in my email. I email the trustee and I say, you have authorization to sign this for me. And then everything gets signed by the trustee. So I don't even ever go to closings at this point anymore. I
Yeah,
mean, it makes closing really, really easy.
yeah.
So the trustee signs all of the paperwork at my authorization. I am now the beneficiary of that trust. The trust owns the property, which is really just a vehicle for ownership for that trust. We have the form that we have the title company fill out that allows us to send the doc stamps directly to the state. So now the purchase price does not show up on public record. Because I have a partner, let's say in the deal, we also have a beneficiaries agreement between us, which again doesn't get recorded, isn't public. That just stays between him and I and with the trust company. And that spells out basically the terms of this joint venture partnership. And that's really important to have too. And that's it. And it's just such an amazing tool to use because again, it keeps your company name off public record. It keeps the purchase price private. It protects your interest in the deal, especially when you have partners. It really protects everybody's interest in the deal, your lender, your partner, yourself, because it is titled within its own separate land trust. And it's really easy to set up. It's really just paperwork. There's no EIN numbers. There's no bank accounts that you have to set up. Everything is done with the trust company. And did I get everything? Do you want to add
Yeah,
anything
just a
here?
couple things that popped into my head when you were talking about that is with the partnerships too, it can be multiple partners, or you
Mhm.
can, I mean, we've had as many as 5 or 6 partners. One person is maybe they're putting in 40 or 50, they're going to be kind of the driver. But say, I know we've had some that they've got a couple of kids that have small Roth accounts that they're trying to grow those Roth accounts. So they
Mhm.
make those accounts a small percentage partner, and then they're gonna grow according to their percentage of profit.
Yeah.
So it's just a really great tool that you can use to grow your very small retirement accounts, to partner with other people's retirement accounts, that they just really want to be more of a silent partner, but they've got the money in their IRA.
Yeah.
So that's really a really cool thing. And then I forget the last thing you just said that made me think of something. But yeah, the joint venturing. I mean, I don't would never joint venture with anyone. Oh, that's the other thing I was going to say about the deed. Like if you wanted to do that type of thing that I just described, and you didn't use a land trust, how messy would that deed be? You'd have
Yeah.
maybe 5 partners on a deed. You'd have everybody's account, like retirement account information out there.
Yeah.
And if a judgment came against that property, that could be a real issue for those accounts doing
Yeah.
other business or things. So it's just such a good way to protect that type of situation.
Yeah. So we also have listeners from other states. Now, Florida, you said there are statutes, which is awesome.
Mhm.
I think didn't Walt Disney buy all the land down in Disney using trusts? I
Yes,
mean,
and he used land trusts. I mean, this
using land
actually,
trusts.
I believe that the land trust statutes in Florida, I mean, they're patterned after Illinois. Illinois is the forerunner with the original land trust statutes, and ours pretty much are a clone of theirs.
Hmm.
And they were implemented in Florida, I think partially to help Disney. Obviously, the state was probably given a little heads up as to what was going to be happening here, which was great for our state over these past, 50 years. So he actually sent out many, many different investors buying, pieces of property in trust, and then afterwards putting them all together.
Yeah, because if could you guys imagine if Disney started going and buying pieces of property and purchase prices started showing up on public record and people got wind that, hey, this guy's coming down here to purchase all these different pieces of land, what would happen is my price would go up, right?
Yeah,
Because I know what he's doing. I know what he's buying them for. So he was
right.
really smart. He used land trust to purchase all these little pieces of property, which now have become Disney World, which is like a
Yeah.
city in and of itself. It's gotten
And
so
that
big.
brings up the other thing I was thinking when you were talking a minute ago is a lot of people ask me, well, how can I, should I have an LLC or should I use a land trust? Well, I always like to tell them you should do both because the land trust is the top layer that's protecting the privacy so that people can see that, yeah, I have 5 or 6 rental properties in my LLC. You don't have to, you can have several different trusts with the same beneficiary underneath.
Right.
That way, instead of having, because a lot of people say, oh, my accountant says put each different rental property into a separate LLC. Well, that can be a lot of costs. You've got your LLC costs, you've got your accounting costs every year. Instead of one K1, you have multiple K1s. So using maybe one LLC for 5 or 6 rental properties, or one LLC is your ordinary income flip,
Yep.
LLC that you're going to put your flips in. That can really be more cost effective from an accounting standpoint as well.
Yeah. So you guys just to recap as with an example, let's say I have an LLC that's called My Properties LLC, and My Properties LLC owns 3 different rental properties: 123 Main Street, 123 Lee Street, and 123 Sandy Street. So that LLC is the owner of those 3 properties, but each property is in its own separate land trust. So I've got 123 Main Street as a land trust, I've got 123 Sandy Street as a land trust, and I've got 123 Lee Street as a land trust. All the same beneficiary. It's all my LLC, My Properties LLC, but each property is protected and owned with its own separate land trust. Don't have to have separate bank accounts again for each one because a land trust does not have an EIN number. You do not have to have a separate bank account that's for 123 Main Street. Your bank account is for your LLC. Everything
Correct.
still falls into the My Property LLC bank account because that is the beneficiary of those trusts, even though each individual property has its own trust.
Right.
Yeah.
Right. And that is a big question that we get as well for people using land trust as for the first time. Some people will take their trust down to the bank and try to get a bank account
Right.
set up, and the bank account's that's not the way it works. So if you
Right.
hold your beneficial interest in your own name, then you're going to use your own bank account. If you hold your beneficial interest in your retirement account and you aren't partnering with someone who's managing it, then you're probably going to have checks coming for all your expenses coming from your retirement account and checks going into your retirement account. So a lot of people use 401k plans where they have their own checkbook. That works really well as a beneficiary.
Yeah. Well, and this really simplifies the partnerships that you might enter into. So, let's say you've got 2 different examples. One where you're not going to use a land trust, you're going to partner with someone. Let's say your LLC is going to partner with someone else's LLC to purchase this property. Technically, if you're going to do it without a land trust, you should have its own separate bank account. There's EIN, you might form another LLC, which you guys are partners of. You might have another bank account. It could get really complicated and a little bit messy. Versus if you're going to put it into a bank account or put it into a land trust where your LLC is a beneficiary of the land trust and the other person's LLC is a beneficiary of the land trust. There's no other LLC that you have to create. There's no bank account that you have to create with each other. Again, everything goes through to the LLCs that are the beneficiaries of that trust. And then you've got the beneficiaries agreement that says this person's going to front the money, this person's going to do this person's going to do that. And if they don't uphold their responsibilities, these are the consequences.
Yeah. I think because of all the added protections you just recapped, it makes it more appealing to do deals with maybe newer investors, because you do have all these things set up. You don't have to go out with a new person, set up an LLC, try to, so it's a good way to mentor people is through having them, hey, why don't you be a small percentage of my land trust and
Right.
you can add this, whatever they're going to bring to the table to be part of the deal.
Yeah, and that brings up another point is that you can have different powers within the land trust. So I'll give you guys an example. Someone had brought us a lead, but they were someone new who didn't quite know what to do or how to negotiate the deal. So we said, well, we'll negotiate the deal. We'll partner with you on it. So they came in as a 10% partner because they just brought us the lead. We negotiated the deal. We put up the funds. And so they came in as a 10% beneficiary of that trust. But we wanted all the power in the trust because we were purchasing this with our funds. We had negotiated the deal. We were running the renovation. So you can make someone a director of the trust, which means that 10% beneficial interest, they're really a silent beneficiary. I don't know if that's the right term, but they're a silent beneficiary in the trust because they really don't have any authorizing power. They can't email you and say, hey, we want to sell this property, because we didn't give them that power in the trust. I was the director of that trust. So I'm the one that says, hey, we're ready to sell the property, or we want to do this, or we want to do that. I'm giving you the authorization.
Right. And even when you do have partners in different percentages, unless you have, specified in the trust that there's one partner that's going to make a decision, we're going to require authorization from each partner for selling or whatever things you want, even for permitting. Like say, somebody wants to do something on the property, they want to hire somebody and take a wall out or whatever, we're going to require all the beneficiaries to give us authorization to sign on a permit like that.
Right.
But if there's a director appointed, then we wouldn't need to do that.
Yeah. And I would say too, when the property is in a trust and you are the beneficiary of that trust, you'll also get a document that is a management. It's called a management agreement, which basically allows your company to manage the property so that the trustee doesn't have to sign off on everything. Now, the trustee is going to have to sign off on things like permits and obviously selling the property, any closing documents. But let's say I want to sign a lease with a tenant. I don't have to go to the trustee and have them sign the lease because I have a management agreement that allows me to sign the lease or to start the utilities or the electric, things like that.
Right, exactly.
Yeah. Okay, I think my last question is, so we have a lot of listeners in different states. I think I was starting to go into this question when we started about Disney, and that led us off into another a direction. But you guys work with different states as well. It's not just Florida, correct?
Correct.
Okay.
So the land trust statutes are on the books in, I believe, 6 states, including Florida. Like I said, Illinois, I know Hawaii's one. I can't off the top of my head. When I do my presentation, I have it on my PowerPoint, so I never memorize it. However, all 49 states, not Louisiana, because it's based on French law, but the other 49 states are based on English revocable trust principles, and a land trust is a revocable trust. So technically, a revocable trust can be set up in 49 out of 50 states. What can be the issue is that you need to still look at each state to make sure it's going to work the way you want it to work. So in some states, even in the revocable trust statutes, they require the trustee to have more of an active participation in the property. Now, obviously, we don't do that. So it doesn't mean you can't have a land trust in that state, but you're probably going to have to be your own trustee, or you're going to have maybe someone that's going to be a partner or a close friend or somebody else be the trustee, because we operate really only under Florida principles, which is we have only administrative powers. We do not do anything to manage your trustee, so your trust property. So that's one thing that we always look at when people there's certain states we know we can do them in, but that's one of the things that we will look at. And then there's one state in particular, I believe it's Arizona, that requires the beneficiary to be public. Well, I mean, you can have a land trust for some other reasons, like the lien in judgment reason and the successor beneficiary to avoid probate, but it doesn't really help you with privacy if the beneficiary is going to be public. So obviously we don't do land trusts in those states. So there's several that we don't do them in just because it's not doesn't fit in our the Florida statute guidelines. But there's several that we can. So
yeah. And I remember when I was first starting in investing, I lived in Florida, but we were back and forth between Florida and Georgia. And I remember calling a couple of different places in Georgia to see if they would do a land trust. And they said, no one does land trust here. We don't do land trust. You don't need land trust in Georgia. And so I was like, okay, so we bought that property. I think we did 2 or 3 flips there in Georgia before we came back down to Florida. And it was always a problem because
Yeah.
we hadn't put the property into the trust. It just always became a problem when we went to go sell the house because of what we purchased it for versus what we were selling it at. And in hindsight, I probably could have set up a trust in
Mhm.
Georgia, but I just didn't, no one in Georgia that I was speaking to did them.
Yeah.
Um,
And that
so
is the challenge, is even if you're doing one in a state where it's non-statutory, even though you can do it and the laws are okay for it, your title companies get all confused. And there's
right,
several states that they call a land trust. It's more of a conservation trust, and land trusts are used for those types of properties that are never going to be built on. So that
right,
can be confusing for those title companies too. So there's a lot more education that might come into play when you're trying to do that in a different state that doesn't recognize land trusts.
right. Are there any other things that you can put into a land trust besides a house?
Mortgage. So we have like a recorded interest. So I know you and I did a deal once where we did an option, because you're doing when you're recording an option, notice of option, and the option mortgage to secure option are both recordable interests. So we did an option deal where we did the mortgage in the trust.
That's
It's either
right.
the mortgage or the option, but we filed whatever it is, we recorded it, and then we had an interest in that property.
Hmm.
So any property interest that can be recorded can go into a land trust.
Okay. But things like personal property, RVs, boats,
No,
not.
no, they cannot be held in land trust. No, no, it's
Yeah.
got to be recordable interest. Now, yeah, only time a manufactured home can be is, of course, if it's tied to the deed. So a lot of times we'll have the land is in the trust, but the manufactured home, for whatever reason, when it closed, it didn't get placed into the deed, so technically it's not in the trust.
So
So
it has to be on the deed in order
on the
to be
deed.
placed
Yep.
into the trust.
Yep.
Yeah. Okay. Okay. Gosh, I don't think I have any other questions, but you guys have a lot of education and
Yes.
resources that people can go to. Where do they go to for that?
Yes. You can go to yourlandtrust.com. So it's commonwealthlandtrust.com, but Your Land Trust is kind of the shortened version of our website. And we do have a lot of educational videos. You can also follow us on Facebook and on LinkedIn. We probably are more active on Facebook. We also well, we haven't really been doing them since COVID. I've done a few online speaking engagements in the last year, but we used to hold just, small informational little, probably 3 hour just educational courses here in our office in Longwood, and then we
Mhm.
would run those live on Facebook when we did it.
Yeah.
So yeah, we have a lot of ways. You can also call our office too. My business partner Augie Bylot is a longtime investor. He's probably done, I don't know, upwards of 600 deals himself. So we often talk to people about how to structure their deal when you're just not familiar. Like, they know the land trust is going to help them, but they're not sure how. So especially with options, that's one of the things people want to put an option on a property. And so we help them with that.
Okay. And one thing we didn't touch on is how I think cost affordable land trusts are. So what's like the typical cost for a land trust setup?
So our typical trust package is $550. That includes all the documents that we do, our coordination with the title company on the purchase, and your first year of trustee services, which is only $100 a year. And believe me, we accept all the mail. We're in as much communication as you want to have with us. That I think we do a lot for that $100 a year. After your first property with us with the same beneficiary structure, it's a multiple trust discount of $100 off, so it'd be $450.
Yeah.
Now, obviously, if we have, you purchase a trust with us the first time with your own LLC, and the next time you've got 3 other beneficiaries going to be part of the deal, that's not the same beneficiary structure, and that's a little bit of extra work for us. So then it would be the $550. We do a lot of. I mean, I am an attorney, so we do a lot of additional documents that are kind of a la carte, and we can talk to you about those if you need those.
Yeah. I know you've done mortgages, promissory notes, different
Yeah,
things
and
for
I
us.
do that as my role as an attorney, not as Commonwealth Trust Services. But it
Right.
works well because we're also doing the trust documents, so then I can, pretty easily do
Right.
the lender documents.
And you guys are also coordinating with the title company because you're
Yes.
working directly and closely with the title company to make sure it's closed
Yeah, I
correctly.
mean, as soon as we get an order, we reach out to the title company, we get the commitment, we work with them to get it worded correctly so that the trust is insured properly. We'll also work with their lenders. I mean, whether I'm doing the docs or not, we're going to work with whoever is, because I mean, most of these are cash deals, but people are using some kind of private money
Right.
for their purchases. So we'll work with those lenders, make sure that the title policy is correct, the lender policy, and yeah, so we do a lot, of course, like you said, we have so many people that they're out of town when they close. We can hardly
Yeah.
get them on the phone. We're emailing and saying, have you looking at these documents? But yeah, so we get it done. We're doing closings almost on a daily basis here, which, ours are mail away typically. We don't go anywhere. They mail
Right.
us all, but a lot of title companies are very, very used to that now. And if
Yeah.
they weren't before COVID, they are now. So everybody's doing things mail away.
Yeah.
A lot of times they have electronic notaries, or
Yep.
we have 3 notaries here. But once in a while you get some of the bigger title companies like Fidelity with a
Yeah.
million locations, and they want to use their own notaries, so they'll send a notary. So
Okay. Yeah, you guys, again, I don't remember the last time I went to a closing. Typically what happens is we're ready to close. Title company sends me all of the final settlement statements. I take a look at them. I email Andrea. I say, you're authorized to sign. They sign it. We close. We're good. And I find out from the title company the next day, everything closed. So it makes it really, really easy for me to have a life and be closing transactions. I'm not there physically at the closing table. So.
right.
All right. Well, thank you so much, Andrea, for coming
Yeah.
on.
Yeah,
And,
well, thank you for having me. And once again, yourlandtrust.com. You can also call our office at 407-755-1010.
yeah, and you guys, very easy to set up a land trust with Commonwealth Trust. They have an online system where it's basically fill in the blank and you submit it right there on their website. But of course, if you have questions, you can always call them or email them as you're filling in the form needed to get the land trust set up.
Yep. There's
Oh, you know
right
what? I have one other question someone asked.
Okay.
It's a really good question. How does insurance work with a trust? Does it fall back into the trustee's name?
Yes, the insurance, it needs to be titled in the name of the trust, the trustee. Typically, so our trust may be named a couple of different ways, just depending on different things. But Commonwealth Trust Services LLC needs to somehow be in the insurance, because if we get a check, that's how we have our bank account and our trust account set up. So
Right.
there's no trust account for the 123 Main Street and the 123 Sandy Street, and there's no bank account for those. So if the check comes in the 123 Sandy Land Trust, well, where are we going to deposit that? So we typically say put our name first, because they truncate everything. There's Commonwealth Trust Services LLC as trustee of the such and such land trust is actually what it's vested in, and that's apparent on the deed. But typically insurance is going to write all that out. So as long as our name gets in there first, then we're not going to have a problem with the insurance checks and things like that.
Yeah. Also, this is where it's really important to work with an insurance agent that understands trust, because I know in the past that we've had insurance agents that are not, especially the bigger insurances like the State Farms and the Progressive, they just don't know what to do with the trust. They don't understand them. So we use an investor friendly insurance agent who understands land trust. And I know in the past I've done it a few different ways depending on the insurance policy. Sometimes we'll have the named insured as Commonwealth Trust Services LLC. And as an additional insured, it will say all beneficiaries, ATIMA, so that I'm the beneficiary. I'm also covered in that. We've also done it where the insurance wouldn't take that. So we've put our company as the insured, and then additional insured was Commonwealth Trust Services LLC. But as long as Commonwealth Trust Services on there as insured, then you guys should be able to endorse it over to us.
And not only that, but the insurance typically runs with the deed. So you do need to have us on there because we are the one that's got the vested title on the property. So that is important. When you use a corporate trustee, Like it's a little bit different if you're using someone that, that's why we always say, be careful, we didn't really talk about that. Know and trust your trustee, because there is a
Yeah.
fiduciary responsibility that we have as a trustee, that we follow the contract that we've entered into. Obviously,
Right.
I'm an attorney. I'm also monitored by answerable to the Florida bar as well. But a lot of people want to use a relative or a girlfriend who then becomes an ex-girlfriend. And we've heard horror stories about those types of situations. They don't have a trust account that they're putting funds into, and funds are being written to them that you're thinking you're going to get back, and who knows what happens. With us, we have a trust account. It goes in our trust account. It's going to get written out verbatim in the exact amount to the beneficiary.
Yeah. Yeah, that's really important. Make sure you trust your trustee.
Yeah.
Because I can only imagine when you have an insurance claim and it gets sent to your ex best friend who used to be your trustee, what kind of problem.
And that they're knowledgeable. I mean, we get a lot of calls all the time, especially when, there's a lot of investors now. A lot of people are texting us constantly saying, would you like to sell this property? Or who can I talk to about selling this property? So you want to make sure whoever your trustee is, they're willing to put up with that, and they're not going to give your name out as the owner.
Right. Right. Okay. Great question, Ed. I'm glad you asked that. I think that'll wrap this up for today, you guys. Again, if you have any other questions, Andrea is available to talk. They have a lot of resources on their website. Very easy to set up the trust on their website, and they do a great job of giving out a lot of education and resources to people. So,
all right, great. Thank you so much.
Thanks again for coming on, Andrea.
Yeah, you're welcome. Have a great day.
All right, you guys, remember, you are just one deal away. We'll see you on the next episode. Take care.